Madam Speaker, in criminal law generally, an attempt is very different from the actual act. No, an attempt is very different. Just look at it practically. Somebody, even if it's say rape, somebody comes into the room and tries to get hold of you and you fight him. So he hasn't penetrated you. Now, for someone who actually ends up chewing you,
Madam Chair,
can you look?
Where somebody has got your child, imagine the child is 2 years, is 3 years, even life imprisonment is not adequate, because this person is going to go into the prisons and continue living his life, maybe even continuing with homosexuality in the prisons. These people should be castrated. Yes. The amendment I'm proposing is that the person should be castrated, Madam Speaker.
Madam Chair, we have now known that homosexuality is not inborn, it's learned. And the teacher who teaches homosexuality, the doctrine, is actually the source of all this problem that we are talking about. So 10 years, in my opinion, is very minimal. 20 years I propose.
A'udhu billahi minash shaitanir rajim. Bismillahir rahmanir rahim. Assalamu alaikum wa rahmatullahi wa barakatuhu. Nze Haji Kabogoza omusomi w'edduwa ntereza ensonga z'amaka ebyenfuna n'endwadde ezitategeerekeka. Haji Kabogoza omusomi w'edduwa nsiŋŋaanibwa Ekitigoma ku lw'Ejjinja. Bw'obanga otuuse Ekitigoma mu ttawuni ku siteegi osobola okuba ku nnamba z'essimu ezo z'olaba zitambula. Gwe wenna ali ewala oyinza okuyita ku mukutu gwaffe ogwa WhatsApp ku layini eyo eya MTN obudde bwonna mbeerako.
The offense of homosexuality. For clause 2, there is substituted the following. 2. Offense of homosexuality. 1. A person commits the offense of homosexuality if the person performs a sexual act on another person of the same gender or allows a person of the same gender to perform a sexual act on him or her. 2. A person who commits the offense of homosexuality is liable on conviction to imprisonment for life. 3. A person who attempts to perform a sexual act in circumstances referred to in subsection 1 commits an offense and is liable on conviction to imprisonment.
Honorable members, listen.
To imprisonment for a period not exceeding 7 years. Four, notwithstanding subsection 2, a person charged with an offense under this section may, in mitigation of sentence, submit evidence from a medical practitioner appointed by the Medical and Dental Practitioners Council, proving that the accused person was, let me repeat 4, notwithstanding subsection 2, a person charged with an offense under this section may, in mitigation of sentence, submit evidence from a medical practitioner appointed by the Medical and Dental Practitioners Council, proving that the accused person was, at the time of the commission of the offense, suffering genetic abnormalities which may have contributed to the acts that constitute the offense of homosexuality. 5. For purposes of subsection 3, a person shall be deemed to attempt to commit an offense when the person, intending to commit an offense, begins to put his or her intention into execution by means adapted to its fulfillment and manifests his or her intention by some overt act, but does not fulfill his or her intention to such an extent as to commit the offense. Justification: to remove a conflict between the definition of the words homosexuality and sexual act in clause 1 and the prescription of the offense of homosexuality in clause 2 of the bill, since they each prescribed different elements, making the offense of homosexuality vague, thereby contravening the principle of legality prescribed in Article 28(12) of the Constitution. To limit the offense of homosexuality to the penetration, however slight, of a person's anus by another person's sexual organ, of a person's anus, sexual organ, or mouth by a sexual organ of another person of the same gender, or of a person's anus, sexual organ or mouth by an object or sex contraption by a person of the same gender. As guided by court in the case of Kasha Jacqueline, David Katoch Sule and Onzeima
Honorable members, please listen to the chair.
and Onzeima Patience versus Rolling Stone Limited and Gilles Mohammed, High Court Miscellaneous Cause number 163 of 2010, to limit the offense of homosexuality to the actual performance of a sexual act between persons, as required in Section 37 of the Interpretation Act, to prescribe the maximum penalty that can be imposed by court in order to recognize and maintain court discretion in sentencing, to expand the provision to include an attempt to commit the offense of homosexuality, to move provisions relating to sexual orientation to Clause 14 on promotion of the offense of homosexuality, to increase the penalty for the offense in the case of homosexuality from 10 years as proposed in the bill to 20 years, and for the attempts from 2 years to 7 years in tandem with sentences imposed for similar sexual offenses. The proposal to allow a person charged with an offense under the section to mitigate the sentence by adducing evidence of genetic disorders is to recognize evidence from Uganda Medical Association, which explained that a small number of people may have homosexual tendencies because of abnormalities in their genes or biological disorders, to delete provisions that criminalize a person who has not committed an offense of homosexuality.
Thank you, Chair. Yes,
Madam Chair, I want to thank the chair, but why, Madam, I want the chairperson to assist me to understand. Why did you remove the people of the same sex and brought gender? Because the moment you bring gender, a man will come and say, I'm transgender and whatever. Yeah, so to avoid this, it should be of the same what? Sex. And the second one, so Madam Chair.
Chair, are you hearing what?
Yes. Madam Chair, the second item, offenses. Yes, first of all, we're moving in line with Section 145 of the Penal Code, where anybody who acts unnaturally must have life what? Imprisonment. Madam, life, okay, whatever. Madam Chair, the moment we allow a space in that law, people will practice it. One, you are saying if you are about to attempt, how do you measure about to attempt? If you are saying you are caught, you are about to practice it, how do you know it? Anybody got with a stolen item is a thief. Anybody who aids somebody to steal is a thief. And the charges of a thief will also apply to the one who aids or who is aiding. So, Madam Chair, I want to implore the chair to agree that the penalties should be the same for those who are trying to procure, for those who are about to practice, so that they all go for life imprisonment. This will deter this act we are fighting.
Thank you. Thank you. Can I hear from Attorney General?
Thank you very much, Madam Chair.
You could answer together. It's similar. Thank you, Right Honourable Speaker. Right Honourable Speaker, I need to be guided, Right Honourable Speaker, because the penalties, because when we read the penal code, if we are to quote 145, what Honourable Fox was talking about, the penalty is death. But also when we refer to the Bible, Leviticus 20:13, what my colleague there quoted, the Bible talks about death. So how do we now degrade the sentence? Yet in the penal code it talks about death, the Bible is talking about death, but we are now degrading it to years or to life imprisonment. I need to be helped. How do we harmonize?
Yes, there is an amendment on the sex instead of gender, That one, take note. Yes.
Thank you, Right Honorable Speaker.
Honorable members, listen.
In response to Honorable Nadala Mafabi, the punishment for an attempt cannot be the same as the punishment for the act itself. That's why the proviso is that the attempt is 7 years and the act is life. That's how it is even in the penal code, where they provide
but we are saying
for
the
unnatural
penal
offenses.
code is obsolete. We are saying the penal code is obsolete. No.
Right Honourable Chair, I am in agreement. I'm in agreement with the proposal by the committee, and especially the justification of consistency and clarity, and the need to address the principle of legality which was disturbing my brother, the homosexualist. Chair, let me clarify this. In the committee, we learned 2 terms. There's a difference between a homosexual and a homosexualist. Honorable Fox is a homosexualist. A homosexualist is the one who protects, promotes, defends. And we agreed that he is not offended to call him a homosexualist. So his concern was the principle of legality. And when you look at the proposal by the committee, it addresses that principle, and indeed
Right Honourable Chair, you have always advised us to speak with evidence. The Honourable Asumani Basalirwa has described the Honourable Fox Odoi as a homosexualist and not a homosexual. Does he have evidence that he's not? Is he in order, therefore?
Information.
Facts speak for themselves. No, by promoting, facts speak for them. Honorable Segona, facts speak for themselves. Yes, can you proceed? By the way, we have so many clauses, we have to move.
So, Chair, I want to invite the August House to be persuaded by the amendments proposed by the committee, because they are consistent and they clarify matters of the law in relation to sexual offenses. And it is not true, Chair, that the penal code proposes death. No, the penal code proposes life imprisonment. Yes. And we want to be consistent. However,
what about the aspect of sex vis-a-vis gender?
Yes, the aspect of sex vis-a-vis gender. Chair, we have not looked at clause 1, but clause 1 has interpreted...
Sex means gender.
Clause 1 has interpreted what gender means. Maybe when we get there, the concerns of the members will be addressed. But in terms of, in fact, gender, as explained by the committee, is broader than even the sex we are talking about. So the committee, maybe the chair, because you guided that we first move away from the interpretation clause. If we went there, people would be able to understand the definition of gender. It carries the concerns. It is not the dictionary definition of gender that people understand.
Honorable Katuntu.
Information.
Thank you very much, Right Honorable Chairperson. Colleagues, I would like to implore upon you to listen to the committee. We tried as much as possible not to offend provisions of the Constitution. as much as possible. Because the enemies of this bill, we know where they are going after here. And that has nothing to do with the honorable folks. But the enemies of the bill, the promoters of homosexuality, we know their path. And their path is a court of law. So, we did our best, Madam Chairperson.
Order.
Honorable members, you have heard what the committee has said. The private member is in agreement with the committee. And in
Madam Chair, Madam Chair, on the issue of sex.
Nathan, please. Colleagues, and please listen. We must, as much as possible, trade within the Constitution, within the law. We have, as you'll see later, we have defined sex, we have defined gender, we have defined sexual orientation, such that there is no gray area at all. And our decision, our opinion was formed by the recent case in Kenya. For those of you who have had time to read it. So, if you have not read the definitions, and it's quite unfortunate, but maybe the chairperson, when you're explaining, we have not reached there, you need to explain to the colleagues that we have already defined all of them. When you go to attempts, including murder, chairperson, in the penal code, there is the case of attempted murder. If you have an attempt, if you're attempting to commit a crime, you can't be criminal at the same level with somebody who has gone ahead and actually committed the crime. So the sentence should differ. What we should be debating, for us we suggested 7 years. For those attempting. If you think we need to raise it, that is okay, we can debate that. But for us, we proposed 7 years.
Madam Chair, before we move to Madam Chair,
Honorable Bariomusi.
Madam Chair, before we move to
Honorable Bariomusi. You're confused.
Thank you very much, Madam Chair. I was raising on another issue, not the sentence, because from what the chair reported, the committee, I think, interfaced with the medical doctors. And the doctors seems to have given a position that there is genetic predisposition, but we are also doctors. Some of us do not agree, and we have looked at the body of evidence. So I want to know from the committee the position which was given, because, Madam Chair, last time...
Are you on the amendment of
yes,
clause
because
1? Clause 2. Are you on amendment? We are now talking about the years.
Okay, because it runs through what the chair raised. But we can dispose of the issue of the sentence, then you give me chance to raise my point, because it runs through the process.
Yes.
Thank you, Madam Chair. Madam Chair, I would want to propose an amendment from 7 to 10. Those who attempt from 7 to 10.
Attorney General.
Ten years is okay.
Thank you. The amendment of 10 years for attempted.
Madam
I
Chair.
put a question that clause 2 be amended as proposed by the committee and amended by the Attorney General with the 10 years on attempted. Those in favor say and the contrary nay. The ayes have it.
Clause 2 as amended.
I put a question that clause 2 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 3.
Clause 3.
Right Honorable. Hello. Right Honorable.
Clause 3, aggravated homosexuality. For clause 3, there is
Right Honorable.
substituted the following.
Honorable members, listen to the chair.
Clause 3, aggravated homosexuality. For clause 3, there is substituted the following. 3, aggravated homosexuality. 1, a person who commits the offense of homosexuality in any of the circumstances specified in subsection 2 commits the offense of aggravated homosexuality and is liable on conviction to suffer death. 2, the circumstances referred to in subsection 1 are where A, the person against whom the offense is committed is a child. B, the offender is a parent, guardian, or relative of the person against whom the offense is committed. C, the person against whom the offense is committed contracts a terminal illness as a result of the sexual act. D, the offender is a serial offender. E, the offender is a person in authority over the person against whom the offense is committed. F, the person against whom the offense is committed is a person with disability or suffers a disability as a result of the sexual act. G, the person against whom the offense is committed is a person with mental illness or suffers a mental illness as a result of the sexual act. H, the person against whom the offense is committed is of advanced age. I, the offense was committed against a person by means of threats, force, fear of bodily harm, duress, undue influence, through misrepresentation as to the nature of the act, or intimidation of any kind. J, the person against whom the offense is committed was at the time the offense was committed unconscious or in an altered state of consciousness due to the influence of medicine, drugs, alcohol, or any other substance that impaired his or her judgment. 3, a person who attempts to perform a sexual act in circumstances referred to in subsection 1 commits an offense and is liable on conviction to imprisonment for a period not exceeding 14 years. 4, a person charged with an offense under this section may, in mitigation of sentence, submit evidence from a medical practitioner appointed by the Medical and Dental Practitioners Council, proving that the accused person was, at the time of the commission of the offense, suffering genetic abnormalities which might have contributed to the acts that constitute the offense of homosexuality. 5, for purposes of subsection 4, a person shall be deemed to attempt to commit an offense when the person intending to commit an offense begins to put his or her intention into execution by means adapted to its fulfillment and manifests his or her intention by some overt act, but does not fulfill his or her intention to such an extent as to commit the offense. Justification: to harmonize the punishment for aggravated homosexuality with the punishment prescribed for similar offenses under the Penal Code. To harmonize the penalty prescribed in this clause with Section 129 of the Penal Code Act relating to defilement. To harmonize the punishment for the offense of homosexuality and aggravated homosexuality. To expand the provision to include other matters that aggravate the offense of homosexuality. To expand the provision to include other categories of infection and incurable diseases that might arise from the sexual act. The proposal to allow a person charged with an offense under the section to mitigate the sentence by adducing evidence of genetic disorders is to recognize evidence from Uganda Medical Association, which explained that a small number of people may have homosexual tendencies because of abnormalities in their genes or biological disorders.
Thank you, Asman. Asman.
Chair, I have no objection to the proposal by the committee.
Attorney General.
I have no objection. I concede.
I put a question that clause 3 be amended as proposed. Those in favor say on the contrary nay.
Information.
The ayes have it.
Clause 3 as amended.
I put a question that clause 3 as amended stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 4.
Clause 4. Clause 4. This
Clause
bill,
4.
This bill has
Attempt
been
to commit
harmonized.
homosexuality. Delete clause 4. Justification. The provisions of clause 4 have been inserted in clauses 2 and 3
Semuju.
of the bill.
Madam
Semuju.
Chair, thank you very much. I will request that we recommit parts of clause 3 because I disagree with 4. The one that says someone can plead that this is genetic abnormalities. Even thieves will say this is genetic problems. So my request is that after the bill we recommit this.
But I
propose-
thought you're a member of the committee. What happened in the committee?
Madam Chair, at a committee stage I am not stopped from making a proposal. I am only stopped from debating during the second.
We'll recommit it. Let's go ahead. 4. Clause 4.
Clause 4. Attempt to commit homosexuality. Delete clause 4. Justification. The provisions of clause 4 have been inserted in clauses 2 and 3 of the bill.
Yes, Your Court. Let me first hear from Asuman. Clause 4.
Chair, no objection.
Clause 4.
Thank you, Madam Chair. Madam Chair, I think we should not delete clause number 4 because clause number 4 is talking about even the intention. Because if you have an intention to commit something which is not right,
Intention has been covered in clause 2 and 3. It has been covered.
if it has been covered up there, then we
Attorney General.
I submit
Attorney
I follow it.
General. Attorney General.
I concede to the proposal.
I put a question that clause 4 be deleted as proposed. Those in favor say on the contrary, nay. The ayes have it.
New clause.
New clause.
Insertion of new clause immediately after 4. The bill is amended by inserting immediately after clause 4 the following new clause. Punishment for child homosexuality. A child who is convicted of an offense under section 2 or 3 of this act shall, instead of the punishments prescribed under the relevant section, be liable on conviction to imprisonment for a period not exceeding 3 years. Justification: to limit the punishment that can be imposed on a child homosexual to 3 years as required in section 94(1)(g) of the Children Act, Cap 120.
Honorable members, we are talking about a child, not an adult. And we have the Children's Act. Asumani?
No, Chair.
By the way, a child does not go to Luzira, they go to remand homes.
Yes, Chair, maybe just to give more clarification, it is the reason why we needed this bill as a one-stop center. Because you see, you are now looking at the Children's Act, you are now looking at the Penal Code Act. And the justification being given is that where a piece of legislation elsewhere is clear on a matter, like this one, you are not going to deviate from it. So when we are talking about children, in any legislation we make, our first point of reference is the Children's Act. So this is just being consistent with the Children's Act, and the 3 years must be looked at from that context that we are dealing with the children.
Yes.
Madam Chair, my concern here is about the mitigation, because if we allow these very people to go and mix up in the prison, can't we suggest and recommend that
That
we
is
open
in
up.
another. That is in another clause. You're moving faster than the House. Yes. Enos.
Thank you so much, Madam Chair. I know what I'm going to suggest is a bit inconsistent with other laws, but I wanted us to redefine a child to be 22 years because the average age. Wait! Why don't you listen? The average age, Madam Chair, the average age.
Now, as a legislator.
Wait a minute, Madam.
I am surprised you don't know what age a kid is.
That's why I put a disclaimer. Why don't you allow me finish my argument? Why don't you allow me finish the argument?
Attorney General.
Madam Chair.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم السلام عليكم ورحمة الله وبركاته. Nze Haji Kabogoza omusomi w'edduwa ntereza ensonga z'amaka ebyenfuna n'endwadde ezitategeerekeka. Haji Kabogoza omusomi w'edduwa nsiŋŋaanibwa ekitigoma ku lw'ejjinja. Bw'obanga otuuse ekitigoma mu ttawuni ku siteegi osobola okuba ku nnamba z'essimu ezo z'olaba zitambula. Gwe wenna ali ewala oyinza okuyita ku mukutu gwaffe ogwa WhatsApp ku layini eyo eya MTN obudde bwonna mbeerako.
Thank you, Madam Speaker. Can we have some order?
Honorable Enos,
For purposes of
you
clarity.
sought to uphold the Constitution, now you want to rape the Constitution.
Right, Honorable Speaker, for purposes of clarity.
Honorable members, listen.
For purposes of clarity, the age of majority is 18 and above.
Years.
Now, for us to raise it, a child to 22, would mean that we are amending the Constitution.
Unconstitutional.
And that would mean that this bill we are trying to pass today would tomorrow be declared unconstitutional on the basis of that.
Today you have guided the property.
Honorable Attorney General, are you in agreement with the amendment?
Yes, right, Honorable Speaker, I agree with you.
Chair, my concern is a child of 14 years is different from a child of 17 years. So if we could have the punishment differently, that could be better.
A child is a child. Yes? Honorable Guang. Yes?
Thank you so much, Madam Chair. The information that is moving around, which is very clear, most of our children who are being lured into homosexuality is all about money. And you know, these children...
Give me the amendment. What is the amendment?
The amendment I'm talking about is the period, if you say only 3 years, these people who are practicing homosexuality may buy off those kind of thing to a child. And the child can be attempted to go in for. Therefore, I would think we should increase the number of years.
How is it related to the amendment?
It is about the child who will be involved in homosexuality. They propose should be in prison for 3 years. That's the proposal they have put. Yes. But I'm saying that time, that period of 3 years is not enough because they can't even go further to convince that child to accept anything of that kind. Then within the 3 years will not be enough. We are proposed it should be increased to 10 years.
Madam Chair, the standard of 3 years
Honorable members
is provided for in other laws.
Yes.
Issues being raised by honorable
members, I want to refer you to the Children's Act. Yes. The law is in conformity with the other laws. I put a question that the proposed new clause stands part of the bill. Those in favor say on the contrary, nay. Let's have it.
Clause 5.
You people, we are not moving.
Clause 5, protection, assistance and payment of compensation to victims of homosexuality. Clause 5 of the bill is amended by A, deleting subclause 1, B, substituting for subclause 2 the following. 2, a person involved in the investigation, prosecution or trial of offences under this Act, shall assist the victim of the offence present his or her views and concerns at the appropriate stages of the criminal proceedings. Justification. Subclause 1 is deleted since it has potential to be abused by victims to commit crimes against accused persons before the acts complained of are investigated by the police and the accused person prosecuted. It will encourage mob justice, and it takes away the accused presumption of innocence prescribed in Article 28(3)(a) of the Constitution. For clarity and better drafting.
Asuman?
I concur, Right Honourable Chair.
AG?
I concede.
I put it.
It is under this clause which talks of protection that I want to re-echo the words of the President when he was discussing homosexuality. He was drawing a line.
What amendment are you making?
Whether it's a nurtured activity or it's an activity due to nature. So we want...
Give me the amendment.
Yeah. Hey. Right Honourable Speaker, the amendment I'm bringing on board is to take care of those people nurturing children into this activity, and to also give them...
It does not fall under here. Give me the amendment that you want to make.
I'm looking at protection.
What about protection?
Protecting the children.
Honorable members, I put a question that clause 5 be amended as proposed. Those in favor say and the contrary nay. Nice have it.
Clause 5 as amended.
I put a question that clause 5 as amended stands part of the bill. Those in favor say and the contrary nay. Nice have it.
Clause 6.
Clause 6.
For clause 6, consent of a victim of homosexuality. For clause 6, they substituted the following. Consent to sexual act is no defense. The consent of a person to commit a sexual act shall not constitute a defense to a charge under this act. Justification: to expand the provision to declare as irrelevant the consent of any person to the performance of a sexual act that constitutes an offense under this act, rather than limiting the provisions to victims of offenses as proposed under the bill.
Husband?
Clarification.
Yes.
Madam Chair.
Next time you don't speak.
I want to seek clarification from the chair whether when they were considering the issue of consent, they looked at a consent that is gotten at marriage. We have had cases where married couples in church procure consent to hold out on heterosexual relationship. When they enter into that marriage relationship, they turn around and go into homosexual activities, subdue the person, and now you are saying consent. Consent, what consent are you talking about? Is it this consent that was procured at marriage, or which consent are you talking about?
Honorable Chair.
Can I help?
In the circumstances, because the victim will be innocent.
Can I help?
Chair rules.
Honour member, this bill is about same-sex relationship. It's not about heterosexuals.
And it's not about marriage.
And it's not about marriage. And under Article 31, marriage between people of the same sex is prohibited. So the issue of marriage of people of the same sex does not arise because it is unconstitutional.
We are talking about heterosexuals, Madam Chair.
This bill is not about heterosexuals.
Yeah, Honorable Chair.
Honorable AG.
Honorable Chair.
Attorney General. Honorable members. Honorable members.
Thank you, Madam Chairperson.
Give me the amendment.
Yes, Madam Chairperson.
The amendment I wanted to make relates to Tinka Simile's concern.
No, that one has been solved. That has been corrected.
Madam Chairperson, it is not. The Tinka Simile's concern was people who go into a marriage as heterosexuals. Thereafter conducting a marriage, they turn into doing homosexuality. When they are in a marriage and they are heterosexuals,
the unnatural acts have been handled in clause 2. Those are natural acts.
Honorable Chair.
Honorable members. Honorable members.
Honorable Chair, on consent.
Honorable members, I know how much you feel for this,
Honorable Chair, on
but we
consent.
must move. Honorable members.
Madam Chair.
Honorable, there is nothing to be corrected here, Medi.
No, I'm talking about consent. Thank you, Madam Chair. Maybe honorable members must arise to the fact that because this may be pleaded as a defense that they were consenting adults, that is why we are clearly legislating that consent shall not be a defense. Yes. That is what they are saying under this act. Therefore, you shall not plead that X and Y consented to perform this act.
I put a question that clause 6 be amended as proposed. Those in favor sign the contrary, nay. The ayes have it.
Clause 6 as amended.
I put a question that clause 6 as amended stands part of the bill. Those in favor sign the contrary, nay. The ayes have
Clause
it.
7.
Clause 7. Clause 7. Clause 7. Clause 7. Sit.
Clause 7, confidentiality. In clause 7,
honorable members, listen, Esther.
Clause 7, confidentiality. In clause 7, delete subclauses 1 and 2. Justification, clause 7, 1 and 2 are redundant since clause 7, 1 is already a practice of court, while 7, 2 is provided for under Article 28, 2 of the Constitution, which allows a court or tribunal to exclude the press or the public from all or any proceedings before it for reasons of morality, public order, or national security, as may be in a free and democratic society.
Asman?
No objection.
Attorney General?
No objection.
I put a question that clause 7 be amended as proposed. Those in favor say and to contrary nay. The ayes have
Clause
it.
7 as amended.
Madam Chair, clause 7 deals with our children. And the penalty provided on 7, Madam Chair, is not fair. Because this is the only way.
What penalty do you recommend?
Madam Chair, they propose 10 years only. In clause 7, they are proposing only 10 years for somebody who recruits our children into homosexuality. So let it be life imprisonment for whoever recruits our children, for whoever gets involved in making sure that our children are involved into this.
No, that Chair, I think for information purposes, that's not what clause 7 is saying.
Honorable Patrick, clause 7 is on confidentiality, and aiding and abetting is on clause 8. So you're legislating ahead. Honorable members, I put a question that clause 7 be amended as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
New clause.
New clause. Sarah, sit. You sit.
Insertion of new clauses immediately before clause 8. The bill is amended by inserting before clause 8 the following: child grooming. A person who A. recruits, transports, transfers, harbors or receives a child for the purpose of engaging the child in homosexuality or any other conduct prohibited under this act. B. displays, distributes or supplies to a child any material demonstrating, depicting or illustrating a sexual act between persons of the same gender or any other conduct that is prohibited under this act. C. shows or avails a child in a picture, video or film showing depicting or illustrating a sexual act between persons of the same gender or any other conduct that is prohibited under this act. Or D. in the presence of a child, performs a sexual act with a person of the same gender or causes another person to engage in a sexual act with a person of the same gender, commits an offense and is liable on conviction to imprisonment for a period not exceeding 10 years. 2. The consent of a child of that child's parent, guardian, person in authority or any other person with parental responsibility over the child to the acts prescribed in subsection 1 shall not be a defense to a charge under this act. Justification: to prohibit acts that expose children to acts of homosexuality.
Cecilia.
Chair, I have a concern on the punishment of 10 years. We have seen some videos moving around of young children of 4 years, 3 years being inducted or forced into the act of homosexuality. Now, in that situation, Chair, a child is completely disoriented as far as sexuality is concerned. Now, how can you prescribe only 10 years? Such people really, even if we are trying to be merciful, should be life. Because your child is damaged. Your child is damaged for life, disoriented for life. These people need punishment for life. They must in prison for life. Thank you.
Chair.
Attorney General. We have an amendment from Imat Cecilia.
The proposal of the committee is 10 years. Mama Cecilia proposes life. If the argument is about the length of imprisonment, we could find a middle ground and propose 15 to 20.
Attorney General,
yes.
Attorney General, imagine it is your own child. Imagine it is your own child, Attorney General.
Yes, amendment.
Thank you, Madam.
Thank you, Madam Chair. Madam Chair.
Yeah.
Madam Chair,
Madam
there's something
Chair.
important I needed clarification for.
Madam Chair,
Honorable members, stop grabbing the microphone. If you're not going to sit, I'm going to put a question. Lumo?
Yes, Madam Chair, thank you very much, Madam Chair. I have heard all words here.
We are looking at the years. The amendment we are doing is on the years.
I'm seeking for some help, Madam Chair. I want to know from the chairperson the meaning of the word queer. I fail to understand it. So that when I'm debating, I understand it properly. Thank you very much.
You will hear it from definition on interpretation. Dr. Baiga.
Thank you very much, Madam Chairperson. Madam Chairperson, the issue of promotion is the biggest problem that we have been having. I am proposing 20 years, but Madam Chairperson, there is something that we have not talked about in promotion. These are the TV programs, television programs, videos, films that have got doses of promotion of homosexuality that we have not talked about.
That one is catered for. It is catered for and 2B. Balmweso.
Thank you, Madam Chair. Madam Chair, promotion is very
very serious, particularly in schools, and therefore I propose life imprisonment.
Jennifer?
Yes, because I'm a victim, personally.
Thank you.
Life.
Thank you, Madam Chair. Madam Chair.
Honorable members.
Madam Chair, I propose that first these NGOs and the bodies that promote, first if it is like kind of an NGO,
Years?
they are banned. That is
It
number
is there,
one.
banning is there. Give me the years.
The years I propose 50.
Thank you, Madam Chair. I propose 20.
Honorable.
Yeah, thank you, Madam Chair.
Not you.
I propose 20.
Thank you, Madam Chair. I propose 20.
20.
Same as 20.
20.
Hello.
Madam Chair, given the gravity of the promoters of this vice, I suggest 30 years as punishment.
20 years, Madam Chair.
20 years.
30 years.
Madam Chair, 30 is appropriate.
Madam Chair, there is a vice that is not listed. There is a vice that is not listed.
Honorable members.
The vice of intimidating whistleblowers.
Honorable members, that is separate. We are looking at a sanction first for promotion.
20 years, Madam Speaker.
20 years.
Clarification.
Attorney General. Attorney General.
I concede to the voices of 20 years.
Clarification.
The Attorney General has conceded to the voice of 20.
Clarification, Madam Chair.
Very
important, please.
Chair, I want to concede on the 20 years. But just to give notice that I have an amendment on this clause.
Which one?
Clause 14. But after we have agreed on this.
Make amendment.
Yeah, Chair, I want to clause 14 of the bill. This is a matter that I brought to the attention of the committee, but it has not been captured. Chair, I want to clause 14 of the bill. I want to amend it by inserting immediately after the proposed subsection 3. Immediately after the following subsection 3, the following. That the Uganda Communications Commission or another regulator may, upon its independent determination that a corporate entity has breached any of the provisions of this section, 1. Suspend or revoke the corporate entity's broadcasting rights in Uganda for a period of 10 years. 2. Require the broadcaster or publisher to censor its content, to eliminate all forms of promotion or publication of material offending this section. And 3. Impose an administrative penalty equivalent to 20,000 currency points. And the justification, Chair, is to empower UCC to provide administrative remedies in cases of breach of promotions of the Act on Promotion. Chair, I say so because I have had concerns from colleagues about material that is aired or broadcast on radio and TV, and sometimes the international TVs that broadcast in this country. So the regulator, which is UCC, should be able to impose penalties and sanctions on those that violate the provisions of this act. I beg to propose.
Segona. Honorable Segona. Honorable Segona.
Madam Chair, the committee was alive to certain principles in determining whether to use the word may or shall. Number 1, we were avoiding something called mandatory because the UCC itself is regulated by a different piece of legislation. Number 2, the reasoning is that there are other penalties
provided for as opposed to this one. So this is just in addition to the other remedies that may be considered by the UCC. And finally, in modern legislation, we normally avoid the word shall because of the different interpretations. Now, for those that think that shall is actually mandatory, it has been defined and interpreted by courts to mean directory in certain cases. So it will not be curing the problem you're trying to cure.
Thank you.
And the word may was deliberate.
That is provided for. Katuntu? It's provided for in 3.2. Check 3.2. 3B2. Honorable Katuntu?
I think the legal regime, the Uganda Communications Act, that establishes the Communications Commission, empowers it under that act to even revoke licenses to companies that have been licensed to carry out broadcasting when they are doing anything that offends the law. It's already there provided for. We don't want to create a situation that we are now trying to, how can I put, you see, the freedom of the media, because we don't want to walk again that path that we are now trying to infringe on the freedom of the media.
When you look at what is provided for in 3,
I am looking at the amendment of Honorable Salwa, not what is provided for, but the amendment. Because what was provided for, to me, I think it is sufficient to handle what Honorable Salwa.
The amendment Honorable Basalira is bringing is provided for in the report. In addition to any penalty stipulated in the relevant provision, 1, impose a penalty not exceeding 20,000 currency points for breach of any provisions of this section, or suspend or cancel the license or other authorization granted to the legal entity to undertake the activity in Uganda.
And it was well thought out. We sat and agreed that that is sufficient. What Honorable Saliva is trying to do is to go beyond that. What we provided for under the report actually is in consonance with what is within the UCC.
Maybe what we can include is the timeline. Okay.
Chair. Yes, Chair. I have read the proposal by the committee. Maybe what we need to add is the duration of the suspension or cancellation. And I want to propose that the 10 years in my proposal be included in 3B2.
Cancellation cannot be for a period of time. That should be suspension.
No, there is Chair. Because I was talking about suspending and revoking, and here the committee uses suspension and cancellation. And the point I want to make is that whatever we adopt, the issue of time must be captured. And I want to propose that the cancellation or suspension should be for a period of 10 years.
AG? Yes.
Madam Chair, thank you very much. Madam Chair, I have a problem with the criminalizing an entire organization, because either one director in a broadcast house or in a print media or an editor has committed a crime. It will be a very big mistake. I want to invite this parliament to get that.
Honorable Semuju, before you go far, when you look at 3, where an offense prescribed under this section is committed by a legal entity, court may hold a shareholder, a director, employee, a manager, officer, or any other principal officer. it is catered
my
for.
problem, right, Honorable Chair, is to begin cancellation of licenses. Because media organization employs sometimes even 1,000 people. Deal with the person who has committed the crime and not the
Court
organization.
has a discretion. It is.
Because otherwise we should have closed the NRM long ago. Because if you have 10 ministers who have stolen Mabati,
Madam Chair.
But you can't criminalize the whole of NRM.
Madam Chair.
Thank you. I want to go to 14.3 B1. Impose a penalty not exceeding 20,000 currency points, which is equivalent to 400 million. I want to propose 50,000 currency points.
Attorney General, is that okay with you?
As Attorney General answers the
Let's first answer the currency.
Madam
currency
Chair,
point.
I actually wanted to move the same amendment, because you see, these broadcasters, once something is set on TV, it's watched by millions of people. So the promotion is reaching out to so many people. Unless we have a deterrent proviso that curtails the activity. On the basis of that, I would go with the 40,000, the 50,000 currency points proposal.
Yes. I want to thank the Attorney General. In fact, Attorney General, I think you have made it easier, because this is also promotion, and earlier on we had passed sanctions for promotion. So when it comes to
of 20 years,
so the time now must go with 20 years.
We are talking about entities.
Yeah.
Companies.
Oh, okay.
Yes.
Madam Chair, talking strictly law, I want to implore the House to pay attention to the observation by the Honorable Semuju. Because in a broadcasting house, for example, there are workers who go on air to do different lawful assignments, either out of sheer criminality or out of excitement. Somebody makes a statement. That statement should not be visited onto the entire corporation. And yes, and this is how we do it, especially when we are talking about penalties. I think we need to reorganize it in such a way that we capture criminality of particular individuals.
Information.
Honorable Segona,
yes,
I read it. Hold a shareholder, director, employee, manager, officer, or any other principal officer in the legal entity to be responsible for the actions of a legal person, and therefore liable for the offense committed and punished as provided for in this section, in addition to any penalty stipulated in the relevant provision.
I don't see that one capturing individual.
In addition to the suspension?
Yes. I don't see that one capturing individual liability. Instead, what I read from that is the corporation shouldering liability of the individuals.
No.
Can I help?
Yes, I would be happy to hear my brother.
Madam Chairperson.
Yes.
An organization commits a crime. Colleagues may listen to me. An organization commits a crime when it is its policy to promote criminality as a policy. Then it is guilty of a criminal act, if it is its policy. However, if you've got individual workers, especially, for example, the media, you have editors, you have reporters, you have anchors, you have presenters, somehow who go and commit this crime, whether on air, you can't now hold the entire organization criminally responsible. You can't do it. However, if it is the policy of this television house called Nandutu TV, Agnes Nandutu, something like that, then you would hold that TV criminally responsible.
AG.
Madam Chair, allow me to say this. While the Honorable Katuntu says we look at what would be the policy of the organization, at no time will you find in the memorandum and articles of association of a broadcaster that they intend to broadcast ABCD. But maybe through regulation, if UCC can find these people culpable for more than once, maybe we can provide, we can have a proviso which says where an organization has been found in a breach
but the
for more than once.
UCC Act has those provisions.
Then if the UCC Act has those provisions, then we leave it to UCC instead of embedding it in here.
Question.
Madam Chair. Madam Chair. Chair. Thank you. Colleagues, I want us to reflect closely on the counsel of Honorable Mulawa Abdu Katuntu. Chair, this provision must be read conjunctively. You don't read it disjunctively, because when you do so, you lose the import. Chair, 3 is about giving courts the latitude. You are saying that you, the director, the manager, the employee, you are criminally liable. That is one leg of this argument. The second leg is that now, in the process of investigation and prosecution, we have found that as a policy, whether written or not, advertently or inadvertently, you are promoting homosexuality, then there is no way as an entity you are going to go away scot-free. So that is the context, the text and context within which we must look at this proposal. It is not about making an organization unfairly liable. It is about finding an organization in one way or the other, directly or indirectly, promoting, aiding, abetting acts of homosexuality. And I think that is why the provision is not couched in mandatory terms. It's not couched in mandatory terms. So, the provision is giving discretion to the court. That at the end of it all, it is saying the court may. And I think it's important for us to put some focus on that aspect. Chair, I want to propose that the issue of the 50,000 currency points and the proposal of the license being cancelled or suspended for 10 years be included, and we proceed.
Clarification, Honorable Ambassador.
Madam Chair, my concern is one. You cannot impute culpability on the corporation unless you have perimeters in place. Unless you are able to say it has been done more than once, now we find you guilty. So
that is provided for in the UCC Act.
So what I'm trying to say is that it would be wrong for us to say it is the policy of the company unless we provide that unless that company has been found to have done this more than once, then we can impute that to be the policy of the company.
Madam Chair.
Attorney General, that's
Madam
why you
Chair,
find, Attorney General, that's why you find
this
all
house
these licenses are provisional.
to a position where even attempt is
UCC
punished.
has powers.
Why are we allowing a company even to do it once? Where I have an issue and a senior will guide is on the liability of a company against versus shareholders. Where do we put the principle of Yes. I will be gladly be guided.
Honorable members.
Madam Chair, I concede to the amendment.
As conceded.
The amendment of Basalira.
Madam Chair, I am very, very much receptive of the proposals of the Honorable Katuntu and the Honorable Asuman Basalirwa. But we are looking at a corporation that does not speak by itself. We are looking at a corporation that employs persons, all of whom are drawn from our own society.
Madam Chair. Madam Chair. Madam Chair, the Honorable.
No, we want to move.
Madam Chair, I concede to the proposal, to the proposed amendment for 50 currency points.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم السلام عليكم ورحمة الله وبركاته. Nze Haji Kabogoza omusomi w'edduwa ntereza ensonga z'amaka ebyenfuna n'endwadde ezitategeerekeka. Haji Kabogoza omusomi w'edduwa nsiŋŋaanibwa ekitigoma ku lw'ejjinja. Bw'obanga otuuse ekitigoma mu ttawuni ku siteegi osobola okuba ku nnamba z'essimu ezo z'olaba zitambula. Gwe wenna ali ewala oyinza okuyita ku mukutu gwaffe ogwa WhatsApp ku layini eyo eya MTN obudde bwonna mbeerako.